Elgizouli, I'm Secretary of State for the Home Department.
Well, lady, I have 20 minutes left. I intend to say nothing further under heading 5, which is the corpus of materials from the EU in respect of the death sentence. We deal with all of that in writing, including addressing the one document, the single document relied upon by the respondent, which is a clause in a MLA agreement with Japan. Could I just, though, identify 2 additional documents that aren't in the bundles relevant to this issue? There's a small bundle in front of you, I hope has red tags attached to it.
So this is you, is it?
This is me, I'm afraid. The first isn't a document that I would normally hand up, but it's important in respect of recital 71. You may recall yesterday in the directive, which refers in terms to consideration of the death penalty. And I just draw this to your attention and just ask you to mark Article 11, because that refers to the recital and the Parliament's understanding of the effect of recital 71.
Could I make a plea, Mr. Hammer? These have come through to us today in PDF form. If they could be sent in Word document form, it would be enormously helpful.
Of course, my lord.
But if it's too difficult, don't worry.
I'm sure that can be done, my lord.
And I was very pleased to receive Mr. Fitzgerald's speaking note in Word, which just makes it much easier for my
Of course, my lord.
limited...
Could I ask you also just to mark on that point that the recital 71 is transposed in precisely the same terms into the explanatory note to the Act itself, and you'll find that just for your note, paragraph 230 of the explanatory note, MS 1457. And then the second document behind this is an updated 2019 regulation. You may have seen in our printed case we refer to 2 regulations that prohibit the transfer of equipment or technical assistance that may facilitate the death sentence, 2006 and 2016, the former considered by my Lord Lloyd Jones in Zagorski. There's been an updated regulation of this year. Could I just give you some references, please, but not take you to them? If you would consider recitals 4 to 6, 8, 29, 39 and 50, and please observe the range of prohibitions in the articles themselves, including a prohibition on providing technical assistance. So that's all I intend to say under heading 5. Under heading 6, can I simply just identify for you the necessity tests within the statute? So the first, if you would go to the Data Protection Act, so in Authorities 1, tab 2, and it's starting at section 35 at MS 1265, of course, my lord, it's Authorities 1, tab 2, and it's section 35 at page 1265. By section 34, there are 6 data protection principles that must be complied with in respect of any data processing, whether it's overseas or not. The first data principle, under section 35, provides that the processing for the law enforcement purpose must be lawful and fair. All the submissions I made yesterday, although addressed to the gateway, apply with equal force, we say, to the question of legality under 35.1. But for the current purposes, can I just show you 35.2b? So it's only lawful if it's necessary for the performance of a task carried out for that purpose. There's an additional necessity test in subsection 3, where it's carried out, the law enforcement purposes is sensitive processing, and that's permitted in 2 cases, the second of which at subsection 5 is where the processing is strictly necessary for the law enforcement purposes under A. So if you're doing sensitive processing, it needs to be strictly necessary, and sensitive processing for the purposes of our case is defined in subsection 8A. So the data reveals racial, ethnic origins, political opinions. Now, you may have seen that there is an issue between the parties as to whether or not this was likely to have been sensitive or included sensitive data. my learned friend's argument is that it can't apply in a case where someone's suspected of heinous acts of terrorism. You can't fall within those provisions. Can I just give you the references in writing to where we respond to that as a matter of both principle and practicality? We deal with that at paragraphs 1320 of our printed case at MS 312. And the Information Commissioner responds to it at paragraphs 44 to 47, MS 407 of her case. Although ultimately we say in this case it doesn't actually make a difference because the nature of the decision that's under review is one that you're going to apply in essence a test of strict necessity to in any event because of the subject matter. So it's a very important, it's an important point of principle, but not one that we say makes a practical difference in this case. Finally, you would have seen under the special circumstances gateway in section 76 an additional necessity test. So the necessity test is built into the statute. As to the standard review, obviously the courts will be well aware of the test to be applied. Can I just give you two references though? The first, which is the general way under EU law, the test of necessity will be applied in a data processing case. And you'll find that in the opinion of the Grand Chamber of the CJEU, in opinion 115, see in particular paragraphs 133 to 140, MS 2109, and then a domestic authority applied in the context of death penalty in data processing, which is again the judgment of Mr. Justice Green as he then was in Zorlin. That's A1 tab 13, MS 1716, paragraphs 49, 53 and 98. Can I turn then to heading 7? Can necessity be made out here? Our primary case is an obvious one. It can never be necessary within the meaning of the Act to transfer data where it would be instrumental in the breach of an absolute fundamental right. You could only do that if you have a full assurance, a view that was shared by Mrs. May when she was Home Secretary, Ms. Rudd, and as you will see from the papers, the senior civil servants in the Foreign Office and the Home Office. What I'd like to do is focus on our alternative argument. If the court is against us on our primary submission, that transfer, even without any assurance, is permitted under the Act, against everything I've said thus far, even then, the test of necessity cannot be made out. And that is because there were less restrictive measures available, namely the realistic prospect of the indirect assurance that had been offered by the Americans. It was offered in March of 16, and it was never expressly taken off the table. Now, the evidential source for all of that is contained in Mr. Bigger's statement. It's in Core Volume 2 at paragraph MS 491. Not all the exhibits to that statement made it into the core bundles, but they are all contained in Appendix Part 2. And no doubt the court will want to read those carefully, but we have produced the table, which is behind tab 5 in yesterday's hand-up file. That should be appellant's chronology regarding the offer and availability of partial and direct. Can I just take you, nice time, just to a few inserts, just to make good some points. If you could start, please, at page 2 of that summary. You'll see the Home Office checklist on the 16th of May of last year. So you'll see the US have confirmed their assurance only covers the direct use of the evidence, doesn't cover the derivative use of the evidence, which still materially contribute. We have previously notified the US the assurance is inadequate, pressed for a full assurance, which to date has not been provided. At official level encounters this year, the US line has been the assurance may no longer be on the table, but if it was, would the UK accept it? Pending a ministerial decision, we've not yet provided a response. If you go over the page to page 3 of the summary, we can see the second entry on the 24th of May. This is the capping note. Departing from HMG's normal policy would clearly be a big step. We may not need to. We are working with the US Department of Justice to see if they'd be prepared to volunteer option 2. So there's still ongoing discussions. And they're just down we could clarify whether the direct use assurance previously offered is still available, and in such event that it is, notify the US that we accept it and provide the evidence on this basis. Such an assurance does not completely remove the risk. And it's hard to judge whether option 2 would be received any better than option 1 at the political level. We're trying to test that. It is possible that they would see it as sufficient concession. And then just down then, to skip a box to the 29th, email from the private secretary recording minister's decision. So at this stage then, without any suggestion in the evidence that the discussions with the DOJ have stopped, or there's been a refusal to provide a direct insurance, the Home Secretary indicates that he is minded not to seek any assurances at all. Over the page to page 4, in the chronology we see at the top is the 30th of May, that's the meeting between the Home Secretary and Mr. Sessions. The following day, there's a Foreign Office submission to the Foreign Secretary which recommends that we maintain a position and seek a full assurance, but notes the ongoing possibility of a partial insurance. So the FCO submission, under options, option A you can see is full assurance. That was the one that was recommended by FCO and Home Office officials. Option 2 is the direct use assurance. And then we've an excerpt from paragraph 16. We could clarify whether the direct use assurance previously offered is still available, and the event that it is, notify the US that we accept the direct use assurance and provide the evidence on this basis. And then on the 11th of June, the Home Secretary writes to the Foreign Secretary, in which he makes a reference to the partial assurance still possibly being on the table, but conveying his view there shouldn't be any assurance at all. He says, the US has, however, refused to provide an assurance in these terms. That's a full assurance. The assurance it has formally offered is a partial one, covering direct use. My officials judge that this assurance, even assuming it's still on the table, doesn't fully mitigate the risk of US evidence contributing to the use of the death penalty. In deciding whether to maintain the then Home Secretary position, I've considered the consequences of sharing evidence without a full assurance. I concluded that significant attempts having been made to seek a full assurance, it's now right to accede to the request without any assurance. Can I make 3 points, please? First, we say it's clear that the direct use assurance was still a possibility, and indeed the subject of ongoing discussion at the time of the decision was made to transfer the data without any. The respondent's explanation in the letter I've just shown you the excerpt to, for not seeking any assurance at all, defies logic. He acknowledges that the partial assurance might still be on the table, but in light of the fact that full assurances aren't available, he decides to proceed without any assurance at all. Now, there is simply no logical connection between a statement that a full assurance cannot be attained and the conclusion, therefore, that the MLA should be provided without any assurance. Where there's a range of possible outcomes, the fact you cannot procure the best outcome does not mean you must automatically accept the worst. Second point is, whilst of course we accept that one would normally give considerable deference to the weight exercised by those holding the highest offices of state in discussion with foreign counterparts, from a necessity perspective, limited weight can be placed on Mr. Javid's assessment at the meeting with Mr. Sessions, that even raising the matter of assurances, including partial assurances, would be so damaging to UK interests that it was necessary to refrain from raising it. That's for a number of reasons why, not least the statutory test of necessity compels you to consider whether it was strictly necessary. For the reasons I gave yesterday, the Home Secretary did not have in his mind the correct legal test at the time of that meeting under the DPAs. He also went into that meeting, as Mr. Bigger makes plain, having already made up his mind that he wasn't going to seek any assurances at all. And he would only consider discussing direct assurances if Mr. Sessions himself raised it. And we say with great respect, it's simply contrary to common experience to conclude that the matter could not have been raised by the Home Secretary by way of sensitive, cordial conversation, couched no doubt with diplomatic reserve, in a matter that would not have enraged Mr. Sessions. If indeed we've come to the point that that is now the litmus test for whether or not we maintain our public commitment to human rights.
So much depends on impression, doesn't it? I mean, It may well be that the Home Secretary got the mood of the meeting when he met Mr. Sessions, and that it was clear that he was not going to get anywhere with seeking any assurance. He may not have articulated that in the precise manner that you say is required, but that's at least a possibility.
Well, my Lord, I accept that is a possibility, but it is not one that is made out when you consider the documents in detail in this case. On a life and death matter where you have a less restrictive option available to you, to not even raise the possibility of accepting an offer that the United States had raised, in which there were still ongoing discussions with the Department of Justice, cannot be justified under a necessity heading. The third point we make, and it's a short one, is that in respect to future transfers, because there is a renewed application for judicial review, and we would say, therefore, the possibility of actually criminal proceedings here, that the proposed future transfer cannot be deemed necessary at this stage. Could I move to my final heading? We've compiled in this morning's hand-up a list of procedural failures, so you have it all in one place. And can I identify 5 reasons why contemporaneous consideration of the Act prior to transfer is an essential part of the statutory regime? Firstly, the protective purpose of the directive and the Act would be negated if controllers were permitted to disregard its requirements at the time of processing. You simply can't process first and consider your duties later. Secondly, the need for contemporaneous consideration is clearly signposted in a number of the provisions of the directive and the Act, and we provided examples at 10.8 and 15.2 in our printed case. A transfer undertaken in complete ignorance of a statutory gateway, for example, cannot be sensibly characterised as being based on or in reliance upon that gateway. Third point is, as the Information Commissioner observes at paragraph 67 of her intervention, the expressed requirements of necessity under the first data protection principles and the rules governing international transfers require the data controller to consider alternative ways of causing less interference. And it's hard to see how a controller can satisfy that requirement or demonstrate they've satisfied that requirement if they don't give prior consideration to applicable gateways and the principles that underlie them. Fourthly, it's self-evident that much of law enforcement processing will take place in secret and without the data subject ever being aware of what's being done with their data. Indeed, this case only came to light because of a leak to a national newspaper. Breaches are therefore particularly unlikely to be identified, challenged, and rectified. So to avoid a large number of unrectified breaches occurring, it is essential to ensure the requirements are actively processed. Fifthly, it's self-evident that much law enforcement processing will be practically irreversible. Many breaches will be impossible to remedy effectively, and so therefore a priori consideration of the Act's requirements is essential to avoid irremediable harm being done to fundamental rights of data subjects. And so it's for those reasons we say that respondents should not be allowed to retrospectively shoehorn into either substantive legal tests in this case, nor be excused for procedural default. My Lady, unless I can assist the Court further, those are the submissions on ground 2.
Well, you've galloped through it at a great pace, but I hope we've managed to take enough of it in. Thank you very much indeed, Mr. Hammond.
May I just make another plea?
Yes.
All the documents that have been handed up during yesterday and today, it would be wonderful if they could all be forwarded as a Word document with an index so that we could identify the source of it.
Well, and it may be if there are further hand-ups, my learned friends, we'll work together to make sure you have it in one.
First rate.
In one document.
Thank you very much indeed.
I'm here on behalf of the Information Commissioner. I've been given up to 20 minutes. I intend to keep up the galloping pace, and I hope perhaps to finish slightly faster than that. In making my submissions, I'll be referring principally to 3 documents: the Information Commissioner's written submissions, which are at Core Volume 1, starting at MS page 396, and then briefly to sections 34 and 35 of the Act, which you were just taken to, which is at Authorities 1, Tab 2, MS 1263. And then I may refer also to the Law Enforcement Directive, although probably not necessary to turn it up. But the reference to that is Authorities Volume 2, Tab 19. MS 1953. The Information Commissioner has made submissions on 4 discrete points arising under Ground 2, the data protection ground. By way of context, the Commissioner has intervened in this case really for 2 reasons. First, because it's the first occasion on which this court has had reason to consider the 2018 Act and the new regime which came into force last year, and in respect of which the Commissioner is the statutory regulator. Second, and perhaps more importantly for present purposes, because the Commissioner disagrees with certain aspects of the reasoning of the Divisional Court on the data protection points. The Commissioner is concerned in particular to ensure that what appears in this case to have been a failure to comply with the requirements of the Act, or at least to give conscientious consideration to those requirements at the relevant time, should be clearly and correctly identified. And from the regulator's point of view, it is important that the procedural and other requirements in the Act should not generally be read down or weakened simply because of the unusual and rather unhappy context of this case. The decision by the Secretary of State to provide mutual assistance to the United States authorities was a decision to engage in the processing of personal data. And not just the personal data of the appellant's son, but as you've heard, the data of many other individuals who are mentioned in the information or who contributed to the information. And that being so, the sharing of that data with the United States was and is governed by the statutory framework that Parliament has put in place under the Act, based largely but not exclusively on EU law. As a general observation, the Act is not to be read or applied as a tick box exercise, whereby after the fact, processing that has already taken place may be, as it were, signed off as compliant. Indeed, one of the reasons for the general overhaul of data protection legislation in recent years was a perception that the level of compliance with those laws was not good enough and that stronger, clearer rules and more rigorous enforcement were necessary, particularly in the light of rapid technological developments. And if you need to see explicit acknowledgement of that, one can find it in Recital 7 to the General Data Protection Regulation, which is Volume 9, Tab 92, MS 5091. So the new legislation in general envisages data controllers giving conscious consideration to whether a particular processing operation is lawful, necessary, and consistent with the provisions of the Act. And that need for careful prior consideration is particularly pertinent where it is proposed to share personal data from one controller to another, and in particular, as in this case, to transfer personal data outside of the European Union, where the safeguards applicable under our legislation will no longer apply. Now, turning to the specific issues in this case, in the time I have available, I intended to concentrate on what I've referred to as Ground 2C, which is the application of the first data protection principle. Although it may not be logical, there are 1 or 2 points I might make on Ground 2A, which is the extent to which the Part 3 of the Act should be interpreted by reference to the Charter, but perhaps in the interest of time I'll dive straight into 2C and come back to that if I have time at the end. So Mr. Hermer, my friend Mr. Hermer, took you a moment ago to Section 34 of the Act, and the reference again is Authorities 1, Tab 2, MS 1263. And as you saw there, the way that Section 34 works is that it sets out the 6 data protection principles, and then the actual obligation to comply with them is found in Section 34.3. So you see there in 34.3, the controller in relation to personal data is responsible for and must be able to demonstrate compliance with this chapter. And that reflects what's been referred to in the EU legislation as the accountability principle. So it's not just that there needs to be compliance in substance. A data controller needs to be able to demonstrate that they are compliant with the requirements of the Act. And that, for your note, the drafting there, more or less precisely reflects the drafting in Article 4.4 of the Law Enforcement Directive, which you'll find at Authorities 2, Tab 19, and the MS reference is 1972. So the principles and the obligation are there in 34. One then comes on to Section 35, which supplements the first data protection principle. And if you have that there, it's page 1265. And you'll see that the The first data protection principle set out in section 35.1 is that processing for any of the law enforcement purposes must be lawful and fair. And then 35.2 breaks down what's required for the purposes of lawfulness. And one sees there that processing of personal data for the law enforcement purposes is lawful only if and to the extent that it is based on law, and either there's data subject consent, which obviously doesn't apply here, or the processing is necessary for the performance of a task carried out for that purpose by a competent authority. So the essential elements for compliance with the first data protection principle are, first of all, that the processing is lawful, which itself requires that both that it be based on law and satisfy a necessity test, and then that it be fair. And again, that reflects more or less precisely the similar drafting in Article 8 of the directive, which is set out in our written submissions at paragraph 23, but the MS reference for the directive is 1973. Now, what the divisional court said on lawfulness was pretty brief. It's at paragraphs 188 and 189 of their judgment. And effectively, they said two things. They said, first of all, that the processing in this case was lawful in the sense that it was based on the law relating to the exercise of discretionary power under the MLA Treaty. In other words, it had an ascertainable legal basis based on the law relating to the use of the royal prerogative and the Mutual Legal Assistance Treaty. And that's paragraph 188 of the Divisional Court's judgment. Secondly, and from the Commissioner's point of view, this is an aspect of the reasoning with which we disagree. At 189, the Divisional Court held that a breach of any of the provisions of the 2018 Act itself does not render the processing unlawful within the meaning of the first data protection principle. In other words, it was sufficient to satisfy the first principle that there is an ascertainable legal basis, but you didn't need also to satisfy the procedural and other requirements in the 2018 Act. And the Commissioner does take issue with that analysis for the reasons set out in our written submissions at paragraphs 22 to 24. And there are two separate strands to the argument. First of all, there is, as you've just seen, a distinction in section 35 between lawful processing and the requirement that the processing be based on law. So the latter requirement is merely one element of the overall concept of lawfulness under section 35 and 35.2. The fact that processing may be based on law is a minimum requirement that must be satisfied for the processing to be lawful overall, but it is not exhaustive of the more general question of lawfulness. That question of lawfulness goes beyond merely asking whether there is a valid legal basis that one can point to. So to give an example, processing of personal data which had a valid basis in statute might well be unlawful if, for example, it's contrary to public law. So contrary to a substantive legitimate expectation, if the processing were somehow discriminatory, or indeed if it were contrary to a contractual obligation. So the first strand of the argument is that even if the processing is based on law in the formal sense understood by the Divisional Court, that doesn't equate to lawfulness under the first data protection principle. The second strand of the argument is that in any event, on a proper analysis, compliance with the requirement that, compliance with the procedural rules and safeguards in the 2018 Act is in any event an aspect of the requirement that the processing be based on law. And you see that argument set out in more detail in our written submissions at paragraphs 29 to 33. And the case law that's referred to there will be familiar to members of the court. The argument runs essentially like this. The requirement for the processing to be based on law in section 35.2 of the Act reflects the obligation in Article 8.1 of the Law Enforcement Directive that I referred to and which is set out in paragraph 23 of our submissions. Recital 33 to the directive, which the MS references MS 1957, makes it clear that the reference in Article 8 to member state law is to be read as requiring compliance with the familiar requirements of accessibility and foreseeability in the Strasbourg case law. And indeed, you see at the end of the recital, which is set out in our written submissions, the express requirement for the relevant member state law to provide sufficient guarantees against the risk of abuse and arbitrariness. Now, as this court knows well, the requirement in the Strasbourg case law for a measure to be in accordance with the law not only requires the measure to have some ascertainable basis in domestic law, but also refers to the quality of the law in question, and in particular requires it to be accessible and to afford adequate protection against arbitrariness. I'm not going to obviously take you through the passages which are then cited in paragraphs 30 to 32 of our written submissions. They'll be familiar to the court, in particular those members of the court who were authors of the relevant passages. But can I just give you, our written submissions don't have the MS references, so can I give you the bundle references in the cases which are cited there? CAT is volume 5, tab 51, MS 3433. Begal is volume 4, tab 44, MS 3147. T is volume 8, 77, tab 77, MS, I beg your pardon, my lord. T is volume 8, tab 77. The MS reference is 4539. Gallagher is volume 6, tab 57. The MS reference is 3757. And in the footnote to our submissions, you'll see reference to Digital Rights Ireland and Tele2, which are merely to support the proposition that the Luxembourg court has essentially adopted the same approach as the Strasbourg court. And the references there are to volume 9, tabs 90 to 91, MS 4955 and 5008. And as you will recall...
What's the last MS reference?
5008 is Tele2.
008.
My lords, my lady, if it would be helpful, we can send these by email later if that would be of assistance. Now, that, as you recall, that case law was comprehensively reviewed by Lord Sumption and Gallagher, and he distilled the relevant principle as set out in our submissions at paragraph 32, which is essentially that an excessively broad discretion in the application of a measure infringing the right to privacy will amount, or is likely to amount, to an exercise of power unconstrained by law. So such a broad discretion cannot satisfy the requirement to be in accordance with law unless there are sufficient safeguards exercised on known legal principles against the arbitrary exercise of that discretion, so as to comply with the requirement of foreseeability. And of course, in those passages in Gallagher, Lord Sumption was endorsing the analysis of my Lord Reid in T, which drew that important distinction between those elements of in accordance with law and those elements of the proportionality analysis. So based on that case law, both of this court and the Strasbourg and Luxembourg courts, and contrary to the view expressed by the divisional court in this case, in the present case, just as in CAT, the rules and the safeguards in the 2018 Act must be viewed as an essential aspect of the overall legal framework necessary to ensure that the processing of personal data, whether pursuant to this Mutual Legal Assistance Treaty or indeed any other measure, is in accordance with the law or based on law, adopting language in section 35.2. And that's why we say, paragraphs 33 to 34 of our written submissions, that the divisional court was wrong on this point. Put simply, a failure to comply with the safeguards and rules in the 2018 Act means that the processing will not be based on law and will therefore be unlawful within the meaning of the first data protection principle. Those are the submissions I wanted to make on that aspect, the lawfulness aspect. There's the question of necessity, which is, of course, the other aspect of lawful under section 35.2. We don't make any, the Commissioner doesn't make any submissions on whether that proportionality test is satisfied in this case. There are perhaps two important short principles to note, which are referred to in our submissions at paragraphs 38 and 39.
I do find paragraph 37 very gratifying.
I'm grateful, lady. So I remind myself what we said in paragraph 37.
So prepared to accept the compliment.
Yes, yes, as Sir James says to me, it's a bit of sucking up there. Never goes astray, does it? So on the question of necessity, I can largely rest on the basis of the Commissioner's written submissions, but there are 2 points of principle to note. The first is, as referred to in paragraph 38, that there is in fact Luxembourg authority from the Grand Chamber of the ECJ that a failure to consider reasonably available alternatives prior to undertaking data processing would breach the necessity requirement. And that's the Volker and Schecker case. The bundle reference is volume 2, tab 22, MS page 2196, and the relevant passage is at MS 2230.
Page?
The case starts at 2196, my lord, and the relevant passage is 2230.
2230, thank you.
And the second point is a point that my learned friend just made a moment ago, which is, of course, the concept of necessity is context specific. And one good example of that is indeed the judgment of Mr. Justice Green, as he was in the Zollin case, applying an anxious and intensive review in a death penalty context. On the question of sensitive processing, again, my learned friend referred to this a moment ago, the Divisional Court accepted the respondent's submission that the transfer of information in this case did not include material that would involve sensitive processing. As we understand it, the Divisional Court hadn't seen the information, and the Commissioner, again, there's two important points, I suppose, in our submissions on this aspect. First of all, as we say at paragraphs 42 to 47, the Commissioner would urge caution in relation to the conclusion that the Divisional Court seemed to reach that the information in issue here does not involve sensitive processing, since, again, it's understood to include large amounts of data of other persons, and some of that will, or seems likely to reveal racial or ethnic origin, political opinions and religious and philosophical beliefs, even if one excludes the kind of extreme and violent beliefs that would not be protected under Article 9 of the Convention. And secondly, on the concept of strict necessity, under section 35.5, we've referred at paragraphs 50 to 51 to the explanatory note to the Data Protection Act, which provides some guidance based on the opinion of the EU Article 29 Working Party, now the EU Data Protection Board, confirming essentially that strictly necessary has to be understood as a call to pay particular attention to the necessity principle and have precise and particularly solid justifications. The bundle references for that. The explanatory note is in Authorities 1, tab 2 at MS 1448, and the Article 29 Working Party opinion is at Authorities 14, tab 158, MS 6997, and the relevant passage which is quoted is at MS 7004.
Can I say that last one again, please?
7004.
Thank you.
And finally, my lady, on ground 2E, which concerns the gateways under section 73 to 76, you've been addressed on that. Perhaps from the Commissioner's point of view, there are again just 2 points worth highlighting. The first is the point we address at paragraphs 57 to 65, that although we accept that there's room for argument on the proper interpretation of those gateways, the Commissioner's submission is that the gateways are to be read in a hierarchical way, so that a controller would be expected to rely on the least intrusive gateway first before proceeding through the options. And the reasons we give there, as you would expect, refer to the language and the purpose and the context of the Act and the Directive. And finally, the point we deal with at paragraph 66 to 68 of our written submissions, this is an important point where, again, we disagree with the respondent and the Divisional Court's view, and it's the question of whether the application of the applicable gateway under section 73 to 76 requires conscious and contemporaneous consideration prior to a data transfer taking place. And as you'll see there, the Commissioner's position is that for the reasons we've set out, the correct analysis is that the application of those gateways does require some conscious and contemporaneous prior consideration. And again, as you would expect, we make that submission relying on the purpose and the context and the principle of proportionality. Lady, if I can assist further, I'm happy to do so. Otherwise, those are the submissions for the Commissioner.
I'm just checking, but thank you very much indeed for everything, including the economy of your submissions. Thank you.
Back, please, then, to ground of appeal number 1. My lady, Reprieve intervenes in this appeal because of what it sees as the wider impact of the decision at hand, most particularly the impact on those currently facing the death penalty abroad. For those persons, the government's interventions on their behalf are literally a matter of life and death. Reprieve's evidence outlines some of those regular interventions, ranging from soft diplomacy all the way through to the filing of amicus briefs in foreign courts, all of those interventions are made pursuant to and in furtherance of the government's death penalty policy. What is the government's death penalty policy? I'm only going to do this twice, largely because of the limited time I have, but can I delve into the evidence just quickly? MS page 1107. This is the strategy for the abolition of the death penalty. So it's the second appendix, appendix volume 2, page, in a document that begins at page 1086. Don't you? Internally 646. This is the policy document considered by this court in Sandiford. It is the source of the statements of principle concerning the death penalty and this government. Page 648, for example, second paragraph, long-standing policy of the UK to oppose the death penalty in all circumstances as a matter of principle. What does that mean? Is it capable of exception? The answer to that you will see, page 1107, that's the MS, page 667 internally, my lord. This is the government's core script on what it says and thinks about the death penalty. Do you see under the heading Arguments Against the Death Penalty, we oppose the death penalty in all circumstances as a matter of principle. This principle is absolute. That is the basis upon which the government intervenes abroad on behalf of those facing the death penalty abroad. Now, of course, it's also true to say that the OJSA purports to carve out an exception for that, or at least has done so publicly since 2011. But what matters for this appeal, and what matters for Reprieve's clients, we say, is that from 2011 onwards, despite the OJSA, the government's public stance and conduct has been precisely the opposite. The instances of post-2011 public enunciation and reiteration by the government of its absolute opposition to the death penalty are legion and appear regularly throughout the materials in this case. They appear throughout Reprieve's evidence. They appear, for example, in the context of the export control orders, the business secretary saying to the world that we oppose the death penalty in all circumstances. It's what the UK is saying to the UN. Authorities 14, tab 170, MS, page 7278. We oppose the death penalty in all circumstances and even by way of response to terror attacks. It is what is written in the FCO's Human Rights and Democracy report in 2017, MS page 6804. We oppose the death penalty in all circumstances as a matter of principle. It's what the UK says in its public statements in support of similar statements from the Council of Europe and the EU, MS page 7220. It's what has been acknowledged by this court in Sandiford and other courts in Zor Lin. Most starkly for our purposes, and because it engages the OJSA, is the government's unequivocal statement to the UN, evidenced by the Death Penalty Project at MS page 378, that the UK does not provide mutual legal assistance that may result in the death penalty being applied. That is to say, it does not exercise the OJSA exception. What also emerges from Reprieve's evidence, we say, is that the absolute nature of that policy is what enables the government's interventions abroad to be effective at all. It's precisely why no foreign government or court, especially in the post-colonial context, can say, well, why should we be prepared to be lectured by you when you are doing it yourself? The government's interventions abroad have moral authority because they are founded on a policy and principle of absolute opposition. It's like not paying ransoms to hostage takers. You can't be a little bit in favour of it. And it works. The result is, as Reprieve's evidence shows, that even in the face of extant death penalties and sentences abroad, people are alive because of the government's interventions on their behalf. For them, depriving those interventions of all efficacy, of their basis in logic, may literally mean death. They rely on it for their lives. Now, we say that this isn't merely the disturbing background against which ground one falls to be considered. It is a consequence so unfair that it sounds in law. Now, Reprieve agrees entirely with the appellant on ground one, but we do say that this sounding in law can be considered in the event that the court is against the appellant on ground one. And can I explain why? But before I do, can I venture into one further aspect of the evidence? And that's this: the absence of any recognition in the decision-making process at all of the true consequences of the decision. What you see in relation to the decision in question is, firstly, repeated recognition that it is and represents a departure from long-standing policy. It is, according to Mr. Bigar himself, in his capping note, a departure from normal policy position. There are plenty of other instances where that is recognised. Secondly, the government understood and recognised that it was likely to affect the government's ability to insist on death penalty assurances in the MLA context in the future. I said I'd do this twice. Can I take you to one other aspect of the evidence that still keeps in Appendix Volume 2? Internal page 467.
Electronic?
907. In that paragraph that begins, the FCO's Human Rights Policy Unit recommends, is by and large a recognition, a clear recognition, that this decision will impact on the government's ability to obtain death penalty assurances in similar situations in the future. Nowhere, either here or in the decision-making materials at all, is any examination or even recognition that this is a decision that is going to impact on those currently facing the death penalty abroad, that will impact on the ability of this government to persuade friendly foreign states, or perhaps not so friendly foreign states, not to execute its nationals, that will impact on and affect the government's current interventions on behalf of those persons abroad. The height of it are the last two lines of that paragraph that you see on page 467, a recognition that, quote, it would leave the government open to accusations of Western hypocrisy and double standards which would undermine the government's death penalty policy globally, including the US. That is it. That is a sentence that is then repeated again in other documents, never expanded upon, And it is the limit of the, quote, wider considerations that the Home Secretary claims to be taking into account when communicating with the Foreign Secretary on the 11th of June at MS page 516. That is it. That is the limit of the risk that the government foresaw this decision would have. Beyond impinging on the ability to take death penalty assurances in the future. Now, there are a number of ways that Reprieve could formulate what it says and sees as the public law failings of this aspect of the case. It's a failure to take into account relevant considerations. It's a failure to acquaint with the relevant facts. But of course, this is a decision made in the exercise of common law powers and the prerogative, and so one must understand that context. But what emerges with clarity from Sandiford is that this is a decision-making process which is subject to the principles of legitimate expectation, if nothing else. Paragraphs 50 to 53 of my Lord Carnwath's judgment in Sandiford. We say that that principle is engaged here. Firstly, there is a promise that has been made to those facing the death penalty abroad. Now, I acknowledge entirely there is no general expectation, at least one enforceable in public law, from the mere existence of a policy or practice that absolute opposition to the death penalty will continue. The policy isn't law. But where the government has promised continued enjoyment of the substance of its policy, public law will require compelling reasons not to be held to that promise. And here, the government's conduct in relation to those facing the death penalty abroad isn't confined to mere statements of general policy. It involves affirmative intervention on their behalf in foreign courts and in foreign countries. Those actions, collectively or individually, carry the clear implied promise that the government will not voluntarily undermine those interventions, including by way of eviscerating the policy upon which they depend for their coherence. Promises can include conduct, and these are promises which are clear, they're unambiguous, and they are devoid of relevant qualification. And let me make clear that we say the OJSA exception presents no such qualification at all. And that is because, since it's been introduced, the government has been saying to the world since 2011 that it does not exercise the OJSA exception. And as a matter of law, the mere fact that there is a power that could be exercised is no answer, where the government's conduct has been precisely the opposite over a prolonged period of time. You have on your desks, I think, the well-known Unilever decision. I don't think we need to delve into it. The court will no doubt recall that it included or concerned time limits for this filing of tax claims, which the relevant tax authorities had ignored for some 25 years. It had a practice of not applying them for a considerable amount of time. The fact that there was a power to do what the public authority were purporting to do was no answer when its conduct in relation to that power had been precisely the opposite. So, firstly, there is a promise. This government has made a promise to those facing the death penalty abroad. Secondly, that promise has been directed to a limited class of persons and a definable and ascertainable class of persons, namely those facing the death penalty abroad. Thirdly, reliance on that promise is not required by law as a precondition for the operation of the rule of legitimate expectation. But where it exists, it is singularly relevant to issues of proportionality. And here it exists in its starkest possible form. Reprieve's clients rely, as the evidence shows, substantively on government's absolute policy for their lives. They will suffer profound detriment if that promise is withdrawn. Now, fourthly, that being so, and given that adherence to the promise involves no breach of the government's statutory duties, the law will hold the government to its promise, absent a showing by the government that not honouring the promise is proportionate to the public interest. That is a principle and protection which the courts recognise as standing alongside principles such as fair trial, no punishment without law. Of course, as my Lord Carnwath has already observed in argument, the government's assessment of the risks perceived by it to be in play must be given proper deference and weight. So, whatever reservations we may have, it's no part of my submissions to suggest that the government wasn't correct in assessing that the risk of insisting on assurances was, at least potentially, internment in Guantanamo Bay for the claimant's son and his co-accused with no trial. The issue for this court is on a proportionality assessment whether avoiding those risks by not seeking the assurance was a proportionate reason to vitiate the promises to those facing the death penalty around the world and by risking their lives. Now, the next immediate question, of course, is by what standard must the court approach that proportionality assessment? And I acknowledge immediately that this is an area of law with controversy at the edges, especially in areas of, as they have been labelled in this context, macro politics, where, on the spectrum, from bare rationality upwards through to full proportionality, should the court be reviewing. That is a live issue, as disclosed not least of all by my Lord Carnwath's judgment in United Policyholders. It's particularly a live and difficult issue, whereas here fundamental rights are in play on the other side. But mercifully, and I say that given the limited time I have, it's unnecessary to traverse those waters because, and here lies the significance of the failure of the government to consider at all the position of those currently facing the death penalty. The government has failed entirely to weigh in the scales the impact of its decision on the promises it has made and those who rely on those promises. No deference is due to the government's assessment of where the balance of proportionality lies because the government has never made that assessment. The result of all of that is that this court is not only entitled but required to form its own view of where proportionality lies in this context, as it had to in United Policyholders. Reprieve's submission is that the interference in this case is simply not proportionate. If it had been necessary to submit, we would have said that it wasn't within the bounds of proportionality. Reprieve's evidence tells us that the lives we are talking about, that ought to have been on the other side of the scales, and now must be, are those of the vulnerable, children, women, mentally ill, trafficking victims, drug mules, political activists, victims of torture. Those are the lives we're talking about. These are the examples throughout Reprieve's evidence of people who right now sit in prison cells in Pakistan or Bahrain, relying on the government's interventions in their case. They include, for example, the children referred to at paragraph 74 to 79 of Reprieve's evidence in Saudi Arabia, who are currently being saved from mass executions carried out on a regular basis there because they are protected by the coherence of the government's interventions in their case. They include multiple British citizens. To the list one could add Miss Sandiford herself, who remains subject to the death penalty in Indonesia. We respectfully submit that it requires no resort to the principle of anxious or intense or keen scrutiny to appreciate that the risk to their lives that is brought about by this decision is completely disproportionate to the object of securing a federal trial for the claimant's son and co-accused instead of Guantanamo Bay. Whatever can and is said about that deplorable place that is Guantanamo Bay, its residents are alive. In this case, of course, it may never happen at all. The US may back down if assurances are actually required. But if they don't, incarceration at Guantanamo wouldn't be permanent. It wouldn't be irreversible. There may be a change of administration. It may be closed down. And if it happened, it wouldn't be anything that we have brought about. It would be the unilateral act of a friendly foreign state, not facilitated by the government, and the government's ability to protect from the death penalty in the future would be wholly intact. In the proportionality assessment, the legitimate expectations of those facing the death penalty demanded and now demand that the government be required to retain the coherence of its policy and on which they rely for their lives. The government should have insisted on assurances, and if they weren't forthcoming, accepted the consequences of that. In law, the legitimate expectations of those people should now be enforced by this court. And that, of course, isn't to hold the government to its absolute opposition to the death penalty forevermore. It can change its policy if it wishes. It can decide to facilitate the death penalty if it wishes, but not this way. It could offer no more assistance, and when the last of those promised help have been acquitted, had their sentences commuted, or been killed, it would be free to do as it wishes. This decision is manifestly, we say, disproportionate to the risks that the government perceived to be in play. Can I say one last thing? In the alternative, we do submit that at the very least, those facing the death penalty abroad had a procedural expectation of public consultation before a decision of this momentum was made. Procedural expectations can arise in two forms: the paradigm case of a promise of consultation, but the secondary case, explored by Lord Justice Laws in the Bat-Murphy case, arising where people have simply placed pressing and focused reliance on a policy such that it is unfair, an abuse to proceed to defeat that reliance absent good reason. It's difficult, we respectfully submit, to envisage a clearer example of a secondary procedural expectation case as this, a change in the stated policy of the government that it, quote, does not provide MLA that may result in the death, required public debate. It's no less momentous than the abolition of the death penalty itself. A debate in which the interests of those facing the death penalty around the world would have been considered, and other voices too, including Reprieve and potentially Parliament. Of course, the public interest may justify a change in policy despite its unfair effects, but for the reasons I hope I've already explained in the short time I have. To deny even the opportunity for consultation was required in this case by no pressing public interest reason, much less one even approaching being proportionate to what was at stake for those around the world facing the death penalty right now. My lady, my lords, unless I can be of any further assistance, those are our submissions.
Thank you very much indeed. It would be convenient at this moment for us to adjourn for 5 minutes.
Ladies, my lords, the structure is going to be this. I'm going to do a very brief section on the facts. I'm going to spend most of the time that I have on the breach of the common law obligation, which is going to include perhaps greater reference to international law than you've had so far. And then I'm going to do a short section on the DPA, most of which is quite fiddly and most of which is set out in our written case. So that's going to be a much shorter section at the end. I hope that's the right balance. So far as the facts are concerned, they're dealt with in the judgment at paragraphs 5 to 35. And as you've seen, the claimant's son is a suspected terrorist fighter in Syria. He's understood to be in Syria, held by the Syrian Democratic or Defense Forces. He's suspected of involvement in the beheading of individuals, both British and American, and 2 Japanese in Syria, the beheadings being filmed and then posted on the internet. The seriousness of the crimes which are being investigated at the international level are therefore at the apex of seriousness. And there are the most powerful interests, therefore, in investigation and, if possible, trial, and an equally powerful interest in ensuring that individuals, even suspected of those sorts of crimes, are not simply released back, as it were, onto the battlefield in Syria. He is not a British citizen. He's been deprived of British citizenship on grounds that that deprivation is conducive to the public good under Section 40 sub 2 of the British Nationality Act 1981, and he's assessed to hold Sudanese citizenship. So the claim which is in effect made is made by a person who has chosen to go to Syria as part of Daesh and participate in the appalling events of which his involvement is suspected, a person who is not within the jurisdiction of the UK for ECHR purposes, having placed himself beyond that jurisdiction, and is not British but probably a Sudanese citizen. The decision under challenge here was and is the decision to provide MLA, mutual legal assistance. And so far as the rationality challenge at least goes, it is to the decision in effect taken to provide in the past the tranches that have been provided to date to the Americans. The reasoning of the Secretary of State for doing that, and for doing it without death penalty assurances, is set out very, very fully in the statement of Mr. Bigger, which you have in core volume number 2, at page 491 in the MS numbering. And following. Can I just invite you to take that up, because I can do most of what I'm about to say by reference to that statement. I'm assuming that everyone's got the electronic version of that document. Are you still on the hard copy? It's page 56 if you're on the hard copy, numbering 491 on the electronic. And the key summary paragraph, drawing all the strands of the statement together, is perhaps paragraph 75 on page 72 or page 507. But we would respectfully invite the court to read the entirety of that statement, if you haven't already done so. In a nutshell, there were and are, as I've already submitted, the most powerful interests in bringing Mr. El-Sheikh to open justice in a court system governed by the rule of law for obvious reasons. See bigger 6 and 13. There had been CPS, Crown Prosecution Service, advice that the evidential sufficiency test was not met, and so no UK prosecution was possible. There was no local solution, and there was no international criminal court solution for the reasons given by Mr. Bigger at paragraph 10. And just to go back to the no prosecution in the United Kingdom point, which is dealt with and recorded by the judgment at paragraph 11, the Secretary of State, we submit, properly proceeded on the basis that there could be no prosecution in the United Kingdom, because the independent body which decides those things, and it isn't an executive decision, it's a CPS decision, had looked at the evidence and concluded there was evidential insufficiency. And the Home Secretary is in no position to, and could not, and indeed constitutionally should not, disagree with that decision. The claimant now seeks to place reliance on the challenge which he has brought, or she has brought, to the DPP's decision not to reopen, as it were, that investigation and that judgment.
Can I ask you, Sir James, the fact that there was insufficient evidence to prosecute in this country, in the view of the CPS, but that a different assessment was made in the US, is that because the prosecution envisaged in the US would be on a charge which has no parallel in this country?
I'm not entirely sure. I don't think it was necessarily about that. There isn't an enormous amount of evidence explaining that. That is the position. They're still investigating, as you know. They haven't made a decision about charge or a decision whether or not to prosecute. There are, as it were, straws in the wind as to the reasoning in relation to why that disparity exists. And I don't think there's a terribly clear explanation in the evidence, but I certainly don't think that it is, my understanding is that it isn't necessarily based on different charges, because I think in both jurisdictions, murder, for understandable reasons, has been thought about as a charge. So I don't think it's that. It may be to do with the rules of admissibility of evidence or whatever else it may be, but there's a...
Well, Mr. Fitzgerald suggests that the reason, insofar as he can ascertain it, is that it's conceived to be easier to get the appellant's son to the US rather than to the UK.
My lord, that may be part of it, but I'm not sure it's the entirety of it, because
So
there are obviously
we're in a state of ignorance on this question.
You are to some extent in a state of ignorance, but the Secretary of State's position is that he's entitled to rely and was entitled to rely upon the CPS view.
But just on your anterior point that the Secretary of State, it would be constitutionally improper for the Secretary of State to second guess, if I can use that expression, the CPS. Would there be any constitutional impropriety involved in him making inquiry of the Secretary of State about the possibility of a review of the decision?
Making an inquiry of the CPS?
Yes.
Well, my lord, I'm not sure that if it was cast in neutral terms in that way, there would be a constitutional impropriety in that mere request. But the reality is that that request has already been made to them and is the subject of the ongoing judicial review proceedings of which you're aware. Mm. So there wouldn't be a lot of point in the Home Secretary doing it now. That is a live issue which is contestable.
Perhaps not. But in any event, you don't conceive that it would be constitutionally improper if the Secretary of State had misgivings about the correctness of the decision to make inquiries. Of course, it couldn't change the decision, but it wouldn't be, there would be nothing untoward about him making a request for elucidation.
Well, my lord, there's nothing constitutionally improper about
No.
making requests.
Good.
I certainly accept that. But as you're aware, there are these judicial review proceedings that are ongoing. I say ongoing, they're ongoing by the skin of their teeth, as far as we can tell. That challenge is not relevant for present purposes, because the Secretary of State's decision was based on the conclusion clearly expressed, which no one challenges at the time. Things may change as time moves on, but it was based on a clear decision by the CPS of evidential insufficiency.
Can I be clear? I mean, I understand Mr. Fitzgerald to accept that we're stuck, as it were, with the CPS decision for the time being. But what was the Secretary of State's state of mind as to the likelihood of prosecution in the US? I think you said there's no decision has yet been made as to whether there's going to be a prosecution or whether it's possible in the US. What do you say is the sort of highest you can put any expectation he had of there being a successful prosecution in the US?
Well, my lord, I think the answer to that is they were evidently proceeding on the basis that the US had not reached the same conclusion as the CPS.
Well, it hasn't ruled it out.
It hasn't ruled it out.
It may still reach the same conclusion as the CPS.
It may or may not do. I don't think that can be shut out, and it perhaps goes to a causal point, which we may have to come back to later in the argument. But that door is still open.
But
And
if
at the
one
time of the
comes to a
decision,
sort of proportionality analysis that suggests we should, then the chances of a successful prosecution in the US are surely something which would have to go into a balance.
my lord, yes, but it's difficult to make fine judgments about that if you are the United Kingdom, beyond the US being interested in receiving evidence on a certain basis for the purpose of investigation. And there's obviously a powerful policy interest in both jurisdictions in these crimes being prosecuted somewhere, if crimes they are. So that's as far as one can go, I think. The challenge, just so you're aware of it, is to the DPP's decision to decide not to reopen the original charging decision. And so the position remains that there is an extant decision by the CPS, unless and until overturned in that JR. And the extant decision is that there is an evidential insufficiency. And we would invite you, in the light of some of the submissions that my learned friend Mr. Fitzgerald made, we would invite you, if you do get interested in this issue, to go back to the summary grounds that the DPP has actually put in that judicial review, and to read, if you would, in particular, paragraphs 17 and 22 of those grounds. 17 is quite a long paragraph, but that will give you the position and where they are and all the rest of it. So as I think Mr. Fitzgerald ultimately accepted, even on the position as it is today, the CPS acknowledge at least some possibility of a charge of belonging to a prescribed organisation, but that isn't anywhere close to the gravamen of these crimes, which are obviously to do with the killing of individuals in Syria. And you should note that on the 9th of July 2019, Sir Duncan Ouseley refused permission in the JR. I think the permission is being renewed orderly, but that has yet to be determined. But the current position is that it stands with permission refused on paper. So to go back to the facts and to the options and to Mr. Bigger, that left, therefore, on the basis that it was not the UK, not possible in the UK, not possible in a local solution to prosecute over in Syria, for perhaps understandable reasons, not International Criminal Court, that left the United States. And if one couldn't persuade them to prosecute in the court system, there were basically then two alternatives. And the alternatives were, one, Guantanamo, and two, release in Syria back onto the battlefield. There were, for obvious reasons, the most serious concerns about Guantanamo, which you will need no reminding of. Concerns because of the nature of that facility, because there would be no open justice for the families, because you wouldn't be within the US court system. Concerns on a broader front about radicalization of those who have been and are in Guantanamo. And concerns in particular because this possibility was, as Mr. Bigger explains, high on the agenda of the new administration in the United States when the decision was taken. So the first option was pretty unattractive for a whole variety of reasons, including the exposure of the individual to risks of breaches of what would be regarded as Article 3 or Article 6 breaches in America. The second option was equally unpalatable, release back onto the battlefield. As Mr. Bigger explains fairly at paragraph 34, that was a smaller risk in terms of it occurring, but plainly a much bigger risk, or a pretty big risk, in terms of the thing if it actually happened. So there were powerful incentives indeed, as Mr. Bigger explains, to seek to ensure, if possible, a US federal investigation followed by prosecution. And their view, that's the US view, was that they needed the United Kingdom information and material for that to happen, as Mr. Bigger explains at 28 to 30 of his statement and at paragraph 59 in the final sentence. Add into all of that at the time the decision was made, there was a new US administration with which the United Kingdom was now dealing. And they, as he explains, took a pretty strong position in favour of states taking what the US regarded as their proper share of responsibility for foreign terrorist fighters and the disposal of their cases. There was readily understandable and deep reluctance on the part of the US to accept that the US could not do so, and a perceived line between UK ability and willingness being of obvious concern to that relationship as it went forward. They had a strong position in favour of Guantanamo, rightly or wrongly, or reasonable is irrelevant. We are dealing with the real world in international relations. And the US were acutely sensitive, as Mr. Bigger explains, to the assurances issue. In summary, their position was, we take your burden, you do not tie our hands. And they wanted all of the evidence available and unencumbered. Right or wrong, that was the position especially of the United States Attorney General. And this was a high-profile case with concerns about impact into the broader security relationship with the United States and the damage potentially there. See, for that purpose, particularly, Mr. Bigger at paragraph 57, final sentence, and paragraph 75, Roman 1. And it was for that reason that the issue was given and the balances that had to be struck were considered with particular care, especially as to assurances, at official to official level, internationally, and right up to the very top of the tree. It did plainly include the broader impacts of not seeking an assurance, contrary to the submission that you heard this morning. Can I just give you one reference into the final 3 paragraphs of the Foreign Secretary's letter to the Home Secretary, which preceded the decision, in Core Volume 2, MS 519, as I say, the last 3 paragraphs for that point. But in the end, the judgment call that had to be made about assurances was shot through with diplomatic considerations as to the actions and the reactions of a friendly foreign state and its key actors. There was a mass of exploration and analysis both ways, including revisiting issues about such reactions, advice going both ways, with some advice in the middle from officials, including in particular the last capping advice from the most senior officials setting out the arguments to and for and against, as it were, in a much more measured way than one would discern from Mr. Fitzgerald's summary of the facts. And in the end, advice, as Mr. Bigger, para 41, points out, from the UK Embassy, who it might be thought might be closest to a judgment call about the actions and reactions of the Americans. And to that needed to be added the particular position of the US Attorney General, in effect confirmed at the meeting with the Home Secretary at the end of May, which is dealt with in detail at Mr. Bigger's statement, paragraphs 59 and 60. There were considerable risks, it was judged, ultimately, as Mr. Bigger again explains, with pressing further on assurances. The risk was of leading, in effect, to a decision not to prosecute or to investigate further. And it was judged, and it was clearly judged, that the US would not give assurances, would not give either full assurances or, contrary to the submission that Mr. Hermer made this morning, partial assurances. See, for those purposes, paragraphs 57 and 60 of Mr. Bigger's statement, making it entirely clear that that was the judgment both in relation to full and partial assurances. And so, pushing further, it was judged, it would be both pointless and create serious potential risks with the US unless the United Kingdom was simply going to take the position in any subsequent negotiation, ultimately, that they were going to insist on that. And so the damage that was risked was of the only really acceptable option, namely US prosecution, and with wider damage to international relations and international criminal cooperation thrown into the bargain. And the outcome, therefore, was of the provision of the material, but with the condition that it could only be used in the federal investigation and prosecution and could not be used in relation to Guantanamo without further consent. See Bigger, paragraph 74. So there was no irrational change of position by the Home Secretary. He simply had to confront the judgments that he had to confront by reference to the actual changed circumstances at the time. And so 3 points we submit flow from that factual picture. First, that the decision was subjected to the most anxious scrutiny in an area shot through with international relations considerations and diplomatic judgments. Secondly, there were the strongest reasons as to why it was appropriate and important to provide international criminal cooperation with the US. You need no reminding of the importance of that sort of international cooperation in the fight against serious crime and terrorism. And Her Majesty's government's assistance to international partners to tackle threats such as terrorism, serious organised crime and conflict prevention remains absolutely crucial to implementing basic foreign policy priorities. And the facts here, of course, are about as serious and acute as could be imagined. So it was a decision which had, and this is the third point, a complex of factors feeding into it, all legitimate and all engaging the primacy of executive judgments, international relations, security, criminal cooperation on an international front with all the consequences that would flow from a diminution or breakdown in that relationship. And they were plainly entitled, the decision makers, Foreign Secretary and the Home Secretary, to rely upon the expert assessment, in particular of the British ambassador to the US, as to the likely consequences of seeking full or partial assurances, and as to the damage or potential damage to the US relationship more broadly that might result. It was, if you will, a weighing up of factors in the public interest, paradigmatically for ministers. That's the shape of the factual picture. And to go back to the question my Lord Carnwath asked me, I think the Statement of Facts and Issues, paragraph 6, may be of a little assistance perhaps. No formal charges have yet been brought at either federal or state level. The Secretary of State's view was that it could not be said with certainty whether Mr. El-Sheikh would be charged in the US, either at all or with offences which attract the death penalty. It wasn't known whether, if charged or convicted of those capital offences, the death penalty would be sought. The Home Secretary was simply in a position in which that could not be ruled out for the possible charges for obvious reasons, given their seriousness. and in line with the risk threshold identified in the OSJA guidance, his approach was predicated on the basis that there was a serious risk that Mr. El Sheikh would, if prosecuted and convicted, face the death penalty. And two of the offences which they're investigating carry the death penalty in principle: homicide and hostage taking. So that is the backdrop against which I turn, if I may, to the breach of the common law obligation case. And I make submissions under 7 heads, 7 submissions, if you will, on this part of the case before turning to the international legal position. The first submission that we make is that the nature of common law rights and obligations in a context like this that fall on the Secretary of State are to be found in public law. The common law has developed that system of public law, and the claimant's contention is that within that system of public law there is a hard-edged obligation not to provide material to a foreign state where there is a risk that the death penalty would ensue, because that would be facilitation of cruel punishment. And our submission is that public law, for all of the reasons that I've identified, goes no further than to recognise that rational and proper judgments have to be made about whether provision should be made to the US or not. And that is the appropriate legal context, because public law is highly sensitive to the constitutional balances with which you're very well familiar between the pillars of the state. And precisely the same applies when the state, whether the state is exercising statutory powers or it's exercising powers under the prerogative or the Crown's common law powers. Those sort of hard-edged obligatory controls tend in this area only to be those made by Parliament. Mutual legal assistance, of course, in the form of provision of information and material to a foreign state, is a classic example of the conduct of international affairs. As the judgment below accepted and stated at paragraph 52, it's based in principle on mutuality of cooperation under treaty arrangements with a friendly foreign state. And under the system of public law, as I say, they accepted at 52 that the conduct of international affairs is a paradigm example of an area in which the courts recognise the institutional competence of the executive. And one might add to that the other feature that tends to drive that breadth of respect or discretion, namely democratic accountability.
Do individuals enjoy a common law right in relation to the frequently declaimed position of the United Kingdom that in no circumstances will it facilitate the imposition of the death penalty?
No, they don't.
There's no right there at all.
No right there at all. What they have, because that set of statements represents government policy, what they have is a right to the policy being followed unless there's good reason not to. That's a basic public law principle. But it is for the executive to set that policy, as indeed it has done, with the exceptions that you've seen in the OSJA.
But there is then, on the basis of that answer, a species of right, whether you describe it as a public law right or a common law right, there is a species of right. And your claim is that the contours are that, or at least the extent of the right is that they're entitled to expect the government to adhere to its frequently stated policy unless there are compelling reasons not to.
To adhere to the policy as it actually is. And you appreciate why I put that in there. My Lord says frequently stated.
Well, I hope I do.
Yes,
Perhaps I don't. so
yes, frequently stated, but in a specific policy document, the OSJA, which contains the exceptions. I'm going to come back to that point when I deal with the reprieve.
It's just I want to get a feel for what you say are the contours of the right. I mean, is the distinction that I think you make between a public law right and a common law right one of significance in this context?
It is, I submit, because the public law principles that control allow for policy of that kind, allow for the for all the things that the courts traditionally give primacy to the executive judgments on, international relations and all of that. So that is the framework. What is being contended for, and the case I have to meet, is that there is something much more hard-edged within that, that there is actually a basic principle that you cannot, that the common law should recognise. It hasn't done so far. That's why I'm making these submissions.
But the battle lines, I think, are drawn at a rather more fundamental level, because the appellant asserts that there is a common law right. You say that there is no common law right whatever. There is a public law right which is subject to the qualifications. I mean, am I right in portraying the debate between you at that question?
My Lord, I think you are. It does come down to that. Does the common law impose more than what I submit are the correct controls within the correct legal context, namely public law controls?
Thank you, that's very clear.
I was going to give you the reference to the conduct of international affairs, of which MLA is a species, being a paradigm example of the area in which courts will recognise the institutional competence of the executive. That's a direct quote from the Akaki case, again involving the Lord Chief Justice, Bundle 3, tab 37, electronic 2695, at paragraph 23.
There is obviously a different kind of argument based on the Bill of Rights. I presume you're going to come to deal with that.
I am. Bill of Rights and/or common law. I mean, I think certainly the Bill of Rights argument is there, but it's no more than an aspect of what I call the hard-edged principle that says thou shalt never. And we submit that once you recognise that context and that public law context, there are good reasons why the principle that I've just given you from Akaki at paragraph 23 should apply when you're dealing with international affairs of the kind that we are here. And that is because UK interests are potentially seriously affected, both directly by non-provision or decisions which are made in relation to provision, and their impact on future foreign relations. There are broader risks if there are issues with international cooperation, all the more so if the crime is extremely serious and deals with extremist activity. And the context here involves precisely those sorts of judgments, as I explained when going through Mr. Bigger's statement. But the point at this stage is that there's nothing whatever in traditional public law to suggest the existence of the sort of hard-edged legal obligation as opposed to the constitutionally appropriate and more flexible control of rationality. On the contrary, the importation of that sort of principle into our context would risk cutting across well-established constitutional lines. So that's the first submission. The second submission is that the common law has always developed carefully, incrementally, and with real caution in controversial areas. It deals with precise obligations and issues, and it's very cautious, traditionally, before extrapolating to something much more general, and then simply assuming that an obligation of a very specific kind can be derived, here, in effect, precluding the provision of information where there is a risk of the death penalty. The courts have been astute to ensure that they do not develop into legislative gaps where Parliament has entered the field in controversial areas. The courts will respectfully not tread through the development of common law. And that includes an area in which the HRA itself regulates the area or has impinged into the area. See, for that purpose, if you would, two judgments by my Lord Lloyd-Jones. The first is Zagorski in Bundle 1 of the authorities, tab 12, page 1714. And the paragraph essentially is paragraph 81, which starts with a reference to McCurr. Very familiar with. And then my Lord accepted the submission made by Mr. Chamberlain, recorded about just over halfway through that paragraph. Can I invite you to read from, as Mr. Chamberlain points out, to the end of the paragraph? The second reference, you can put that bundle away, is in volume 3 of the authorities, tab 39, at page 2890. This is a long judgment which records Mr. Justice Leggett. As he then was only a very short time ago, amazingly. And it's sorry, Ed, it's tab 39, bundle 3. And I wanted my Lord Lloyd Jones in the Court of Appeal at that stage, paragraph 200. Page 2890. And it is that same point that is made by the Lord Chief Justice and Mr. Justice Garnham in their judgment at paragraph 66, if you have that to hand. And they do so by reference to a case called Begley in the House of Lords, as you see from paragraph 66. So you've got a variety of different contexts, all leading to the same principle. Of course, in Al Sadoun, it was UNCAT, which had been, some provisions of which had been legislated for, some hadn't. And in Zagorski, it was the HRA, effectively. And you get exactly the same thinking, exactly the same principle. And I'm not going to go, I'll invite you to turn it up now, but in the KU case, if you recall, where there was an issue about customary international law, and whether or not an investigation was required into the deaths there by customary international law. And part of the reasoning disposing of that was that Parliament had now legislated in that territory through inter alia the Human Rights Act. So it wasn't appropriate to drag in any obligation from customary international law because Parliament had intervened and had moved into the territory. The references are in the judgments of Lord Neuberger and Lord Hughes, 112, 117 to 118, and Lord Mance at 151. And KU, if you wanted, is in bundle 2, tab 37, page 4156. That may be the page that gets you to the first of those paragraph references, but that's where you find KU. Of course, therefore, the common law can expand. You had a debate yesterday around the extent of that, and my Lord Reid pointed out that in contexts such as privacy, where you're, as it were, filling a gap in domestic law to achieve correspondence with ECHR rights, there's no great difficulty with that. And of course, it is possible to discover rights in the equivalent context of freedom of expression, which was the subject of the Kennedy decision, which you were referred to, in which Lord Toulson famously declared the common law not to be an ossuary. But its basic approach remains cautious and incremental, precisely because the consequences of establishing a big, broad principle may be very serious and may not be capable of being seen fully. And all the more so when the nature of the steps, it might be thought, because of its, both because of its size and because of its nature, is more apt for Parliament to bring in if truly there is a principle or rule to be established. So that's the second submission. The third submission is that the common law more generally has considered when duties of protection against the actions of third parties are to be imposed, and the position in terms of the rights and obligations that the common law has to date imposed, can we again respectfully recommend my Lord Lloyd Jones's judgment in Zagorski, Bundle 1, tab 12, 1692. And the paragraph for this purpose is at page 1714 in the electronic, and it's paragraph 80. And it is perhaps notable that in neither Zagorski nor in Sandiford, with which you'll be very familiar as well, did the court conclude that the death penalty was a breach of customary international law, for the sake of argument, so that any act that supported or facilitated it, or did not seek to diminish that prospect, was unlawful at common law. If that was the position, if there was implacable opposition followed by something causative, then that would have been easy reasoning and dispositive, if correct. Of course, there may be distinctions in terms of the causative element and how close a species of causation is required, but that is a different issue and a problem, as I will come to in a moment. And in relation to the consideration in the past by the common law of whether our sort of obligation exists, in other words, preventing by a hard-edged principle the passing of information or intelligence to assist a foreign criminal investigation where that state has the death penalty and crimes are of that ilk, there is no domestic authority at all which establishes or comes close to establishing that the government is under any such obligation not to provide MLA to a friendly foreign state in those circumstances. And I would add, friendly foreign state governed by the rule of law, but which nevertheless maintains the death penalty. Fourth submission is that it is not legitimate to seek to build into the common law something equivalent to the right that my learned friend Mr. Fitzgerald asserts exists under the ECHR. I'm going to come as my fifth proposition to whether or not there is such a right or any support under the ECHR system for such an obligation. But even if there were, my submission would be that there would be no basis for incorporating that into the common law, or indeed going beyond what the ECHR might do. And that is because, to go back to basics, ECHR rights apply domestically to create domestically enforceable rights and correlative obligations on the government by reason of and subject to the constitutional constraints in the Human Rights Act. And one of those key constraints, so as to prevent this being a rights charter for all the world, is the concept of within the jurisdiction. There is no obligation under the ECHR or under the HRA, which contains the mirror principle, to secure any right to a person unless they are within the jurisdiction. It is not, as it was put in Bankovich, a doctrine or principle of effects. It's primarily subject to limited exceptions that within the jurisdiction principle. The basic principle is territorial, as you know, and there are limited principles that create exceptions to that of the kind set out in Alskany. But the focus, again, as you know, is on the place of the victim. Everyone within the jurisdiction. It isn't the location of the governmental act that creates jurisdiction. That would be to create a doctrine of effects. And one sees that principle in operation in lots of cases. To take three by way of example only, and I don't invite you to go back to it, Sandiford, paragraph 23, bundle 1, tab 10, page 1661. Akaki, bundle 3, tab 37, page 2686. where it was held that the information provision to Northern Cyprus by the UK police relating to the prosecution of a person in Northern Cyprus did not bring that person within the jurisdiction of the UK so as to engage ECHR rights. There was reliance there placed on both Article 6 and Article 3 of the ECHR, not within the jurisdiction. Parallels with our case are obvious. Also, for good measure, can I just invite you to note the useful analysis of the reception of international law, including customary international law, into our domestic law at paragraphs 21 to 23 of that judgment. I wanted to take you to one case only in the Strasbourg context, which is a case called Abdul Khan, and that's in Bundle 1 at tab 15. You see the basic factual context from the decision of the Strasbourg court. Sorry, did I give you the electronic 1835? You see the basic context if you just flick your eyes down paragraphs 4 and then 5. So they leave the United Kingdom voluntary, as you see. And having left voluntarily, the Secretary of State cancelled leave to remain, as you see from paragraph 6, on the basis that their presence would not be conducive to the public good for reasons of national security. Judged to be involved in Islamist extremist activity, certified that the decision I'm reading from paragraph 6 had been taken on grounds of national security with the consequence that the appellant's appeal would be heard by SIAC. And then they're heard by SIAC and judgments are delivered and so on. And so they effectively complained and the Strasbourg reasoning of relevance for our purposes are the 4 paragraphs between 24 on page 1841 and 28. Can I invite you just to cast an eye down those paragraphs? Key paragraph for present purposes is perhaps paragraph 26, where, as you see, the court says there's no principled reason to distinguish between, on the one hand, someone who was in the jurisdiction of a contracting state but voluntarily left that jurisdiction, and on the other, someone who was never in the jurisdiction of that state. Nor is there any support in the court's case law for the applicant's argument that the state's obligations under Article 3 require it to take this into account when making adverse decisions against individuals, even when those individuals are not within its jurisdiction. So a person such as Mr. El Sheikh, who has chosen to fight with Daesh in Syria, is not afforded protection by the ECHR. He's outside the jurisdiction of the convention by virtue of his position in Syria, where he's currently detained, we believe, by the Syrian Democratic Forces. So Article 3 does not apply to him at all.
I don't think that has been argued, has it?
It hasn't. But it has some important consequences for the nature of the right, which I'm going to come to. So under the ECHR, there is no claim in Strasbourg as a claim because that would be inadmissible ratione personae. And under the Human Rights Act, he cannot and doesn't claim HRA rights in domestic law. For that reason, my Lord Kerr is right. And so the principles governing the reception of the ECHR, or an ECHR right, or a right corresponding to something in the ECHR, when there is no obligation under Article 1 to secure them, can, if it's going to be received in domestic law, only be received because the ECHR is part of international law. And so it would be subject to that body of rules which govern the flow of principles and obligations from international law into domestic law. And again, the principles are extremely well known. The courts have set their face against backdoor incorporation in controversial areas, and that provides a serious constitutional limit on the ability of common law to develop. The classic case is, all those years ago, is Brind, which you have in the bundle 4, tab 48, electronic 3316-7, especially per Lord Ackner.
Is this all still part of your part?
It's still all part of that one, I'm afraid. This is
so.
not legitimate to build into common law, is that? I'm sorry, it's taking a little while. I'll speed
No,
it.
not at all. I just
I'll
wanted to
speed it
keep
up.
clear.
But it's that within the jurisdiction is the first building block, and the second building block is then, so what are you left with? You're left with the reception of ECHR into domestic law when the person can't rely on those rights directly. That can only be governed by the flow of ECHR obligations as an international instrument into domestic law, and the courts are very, very wary indeed about that, as you know from Brind, as you know from cases like the Queen and Lyons, and Lyons, Ronson and Parnes fame. That's in bundle 7, tab 67, 4297 per Lord Hoffman at paragraph 39. And as you are also aware, there are serious limits, even on the reception into domestic law of that species of international law which has attained the high status of customary international law. And those obligations, even under customary international law, are subject to serious constitutional constraints, even as to their reception, i.e. even if you can make good the proposition that something is a principle of customary international law, it doesn't just become part of domestic law. And that is because there are constitutional filters, as it were, which it has to go through for all the reasons that have been explored in many of the cases. Again, I'm going to take you, if I may, back to the Al Sadoun case, because that perhaps contains the clearest exposition of these principles. Bundle 3, if you would, again, of the authorities. Tab 39, beginning on electronic 2736, but the page I want first in the judgment at first instance, which was approved by the Court of Appeal, the judgment of Mr. Justice Leggett, as he then was, at paragraphs 194 to 200, and that's at page 2789, 194, just check the reference. 2800, thank you. Thank you very much. Again, can I just ask you to cast an eye down? False reference. Sorry, I've got it the wrong way round. I'm giving you the wrong references. In Mr. Justice Leggett's judgment, it's paragraph 267. So sorry, I had them the wrong way round. 2816. And it's 267 down to 273, but the key bit for present purposes is perhaps 270 to 273. Referring, and you'll be very familiar with all of these cases, Lord Denning in Trentex, Brownley's Principles of International Law. The quotation that he gives there at 270 from Brownley was then picked up and run with by Lord Bingham in the Queen and Jones, as you recall, which is also referred to at the end of 270. same thinking in KU and so on. So that's Mr. Justice Leggett. And then in the Court of Appeal, my wrong references earlier on, it's Lord Lloyd Jones's judgment, paragraph 194. To give you the flavour of it, because what was being argued for there was, as it were, a transposition of the provisions of UNCAT, in other words, the Torture Convention, into domestic law. And so, again, a pretty serious context. And the answer to that was, well, they don't come in because they don't pass the constitutional filters that are in place in this area.
I certainly don't want to cut you short, Sir James, but none of this has been argued against you. And it seems to me the real burden of the argument, although it may not have been articulated in this way, is not that you receive into or transpose into domestic law the provisions of the ECHR, but if you are trying to fashion or recognise a hitherto unarticulated common law right, it's entirely fitting that you should be, as I think Lord Carswell put it in the A case, you should be exposed to the influences that are germane to that exercise.
My Lord, by all means, but the only reason I'm taking you to these cases, and I'm going to go next to the proposition as to whether or not, even if you were so exposed, you would find the thing that you were looking for.
Well, I did anticipate that you'd be coming up to that.
That's
I just
the next
wonder
bit.
whether, all of this talk about Brind and all of this very well-trodden territory is going
It's
to
well-trodden territory, and I'm sorry to bore you with it, but the only reason I go there and to these paragraphs is to indicate that even if you were to find something in the ECHR which supported a right not to provide MLA, there would still be issues around whether or not the UK common law system could simply drag that in.
I don't think that it has been argued. Certainly, I haven't understood it to be argued that it be dragged in or be received or be transposed or whatever verb you like to use. It's a question of whether, as a contemporary expression of international view about the death penalty, that should have an influence, and if so, what, on the recognition of a common law right.
My Lord, yes, and fine, but my submission remains that influencing is subject to principal consideration in cases like this. And it isn't just a question of saying, there I am, I'm influenced by it. It's a question of saying, what are the principles that govern the nature and extent of that influence? It may not have been argued, I thought it had been, but it may not have been argued that you can transpose, as it were, from ECHR direct in our context. But you've seen from the cases I've taken you to that part of those constitutional restraints are when, for example, Parliament has intervened in the area to govern the situation that you are considering being influenced by. That's one of the key points that's made in these paragraphs and in paragraphs in Akaki that I took you to earlier on. That's why I go there. I'm sorry to bore with it. I will stop.
No, don't apologise.
And go to the next submission. And the next submission is that even were you to open your arms to be exposed to the influence of the ECHR, despite those constitutional principles, there would be no support for the content of the right that they assert in this case, and from which he seeks to analogize. This is Proposition 5. Even if, therefore, you were within the Strasbourg system, the limit of the principle recognised by Strasbourg, we submit, and the HRA, therefore, correspondingly, is a domestic obligation not to subject a person within its jurisdiction to the death penalty. In other words, a preclusion of the execution of the death penalty in domestic law, now contained in the protocols. And the Suring line, well established, Bundle 1, Tab 16, if you want it in the raw. But that is also dependent upon the person themselves being within the jurisdiction and being removed. That was the position in Suring. That was the position in Al Sadoun and the United Kingdom, to which reference has been made. And the correct rationale of Suring and Al Sadoun and that line of cases, we submit, is not that Article 3 or other provisions of the Convention are engaged by virtue of any act by the contracting state which gives rise to the risk of a death penalty. It is action which has as a direct consequence the exposure of that individual by their physical removal to that sort of risk of ill treatment. It is not a doctrine of effects. It's not a doctrine which applies in relation to worrying about domestic decision-making for those who've taken themselves outside the jurisdiction, as we saw from the Strasbourg case of Abdul Khan that I took you to. There is no case in which the European Court of Human Rights or the European Commission of Human Rights in the old days has held or suggested that the mere provision of information to a third country would engage rights under the provisions of Articles 2 or 3. Still less that it would do so as to engage the contracting state's obligation in relation to any person in the world, wherever they may be, British citizen or not. That would truly be to convert it into a doctrine of effects. And there is no good basis, we submit, for distinguishing the Sandiford and Zagorski cases on the basis that my learned friend sought to do by distinguishing between, as it were, action and omission. The Divisional Court correctly, we submit, rejected that case. And they did so for good reasons set out at paragraphs 74 and 75 of the judgment below. One can understand that because essentially my learned friend Mr. Fitzgerald's test and controlling principle is causal. And that just depends how you define things, a failure to ask or a provision of information. Action or omission, both in there, the dividing line between them ephemeral. My learned friend also relied, for this purpose, on paragraph 124 of Al-Sadoun. I don't invite you to take it up again. It's in Bundle 1, tab 14, page 1816 on the electronic. But that paragraph is not setting out some general principle that the ECHR prohibits any act that is causally linked to the death penalty. It's in the section engaging and dealing with state responsibility, and it's explaining why there is state responsibility engaged in the case of a removal of a person.
Which page did you say that was?
It's page 1816. I hope
1816.
that should be 124 of Al-Sadoun.
That's right.
No. It's a long judgment, but I don't think it's quite as... Oh, Al-Sadoun in Europe.
Al-Sadoun in Europe, yeah.
Yes,
Sorry,
yes,
there are lots and lots of Al-Sadouns.
Yes, I'm with you.
The Lord Lloyd Jones Al-Sadoun was a bit later. Same person. So for all of those reasons, we submit that there are not merely no ECHR obligations engaged, but the analogical base from which my learned friend seeks to reason, to invite you to expand the common law, is not made out. The sixth submission is that the nature of any such common law obligation, even if consistent with public law and constitutional principles, would be intensely problematic. That was a subject that was dealt with briefly in the judgment below at paragraph 77, but the problems are real, we respectfully submit, and they go against the creation of an obligation of uncertain scope. How is the principle to be limited or bounded? And what are the consequences on any bounds you try and set on it? So one does need to answer the series of questions such as, well, what is the degree of causal connection that is required? What should be the degree of serious risk, more than fanciful or something else? What about the impact of clemency applications or further appeals? What about the provision of case papers to another country where no criminal investigation has in fact commenced, but they have the death penalty? What type of information, material, or even intelligence does the principle my learned friend invites you to find in the common law apply to the provision of intelligence to a foreign liaison partner? And if not, why not? Does it apply to the deployment of personnel, the giving evidence of evidence in foreign trials by police officers? There are almost boundless questions that would need to be answered before establishing a principle of the requisite certainty with its boundaries set. And even if you were to do that, the consequences of setting the boundaries in any particular place have to be clear and worked through. And we respectfully submit that it's unclear at a very base level how the common law could answer those questions, how it could go about designing those boundaries and that set of principles.
I just wonder whether it is beset with all those potential complications. I mean, surely the yardstick is that you convey to a foreign state information which will put at risk an individual of the imposition of the death penalty. And not only do you do that, but you relinquish any control over the use of that material as soon as it's been transferred. Do you need to get into complications of the type of evidence, or the implications for people being required to testify? Provided those basic tests are set, as I understand it, the appellant says that is all that is needed.
Well, my respectful submission is that you do have to address those, and you do have to address those questions because you've got to decide what the level of risk should be, and then you've got to confront the consequences of that. And I don't just put that out there as a pure point about consequences. What it does is to raise a basic question as to whether or not it is appropriate for the common law to be stepping into this territory and designing that set of principles, particularly in relation to the consequences. I asked a question about intelligence sharing for the sake of argument. What would happen if the intelligence agencies over here, for the sake of argument, found at a stage when there was no investigation or no inkling in a state in America that had the death penalty, if they discovered information or intelligence which indicated that in 3 days' time, a group of conspirators in an American city was going to blow up a school? Now, could they, in those circumstances, consistent with the principle my Lord Kerr has just described, could they provide that intelligence to America? On one view, it would satisfy the tests that you've just set.
Of course, but if you accompany the transfer of the information, whether it be intelligence or whether it be for the purpose of prosecution or whatever, with a requirement that it will not be used in criminal proceedings which can lead to the death penalty. I mean, at the moment, I'm sure it is my fault, I fail to see the difficulty.
Well, my Lord, what happens if you're in a situation exactly of the kind here, where the judgment is that the assurances will not be provided? What then do you do? I mean, I don't wish to question the court, but the rhetorical question is, what happens then? What happens if you're in the very situation we have here, which is that you're confronted with a series of unpalatable options, and you then have to make judgments about whether you do or you don't, with all the ramifications that are provided? What happens then when the judgment call is made for proper reasons, let's assume in the example I've just given, that assurances will not be forthcoming, and the United Kingdom then, for that reason, because the principle has been established by this court, does not provide the intelligence? And then the Americans discover, by accident, in a liaison meeting that happens between the two sets of intelligence services, they discover that we had that information 3 days before the bomb went off and killed all the children. What happens in that situation?
It's always possible to come up with very difficult situations. And of course, you're quite right in saying it's a range of unpalatable choices that have to be made. But that's not by any means the first occasion on which the common law comes up against a range of pragmatic solutions which make it very difficult to enforce it.
My Lord, certainly, as a proposition of general principle, I entirely agree with you. But the debate here is is a serious one, and the debate is a serious one that exists in context. My Lord says, well, it's a set of extreme examples, and of course one's well alive to the whichever Canadian Supreme Court judge it was that said, do never test a proposition by reference to extreme examples. But the reality here is that we are in precisely that territory, because it is by definition only those cases in which the death penalty would be in play in which the issue is going to arise. So we respectfully submit, I don't want to keep banging the drum, we respectfully submit that the position is that you do need to address the question, how are we as a common law court to bound this principle? What is its shape? And when and if you've done that, and you get to a place where there's a potentially satisfactory form of words, then the question is, what are the consequences of that? And those questions are relevant because they go to the constitutional propriety of you doing the thing, rather than Parliament doing the thing, which is exactly the stuff of the reasoning in Al Sadoun and Lord Lloyd Jones's judgment and all those other cases I took you to, Akaki, paragraph 23, and so on. That's a sixth submission. Essentially, its punchline is, this is not, to tie it back to how the common law develops and my submissions on that, this is not a small incremental step by irresistible analogy. It applies to all countries with the death penalty that are over 50. It applies specifically to the US, which is a major partner in international criminal cooperation. And it applies in its logic widely. Why, if the principle is developed by common law, perhaps this is a slightly separate point to finish this sixth submission with, why, if my learned friend is right, does the logic of his argument not extend to all possible breaches of Article 3, or to all those circumstances in which Strasbourg, when addressing this extraterritorial reach of the Convention, has moved it, where there would be, for example, a flagrant violation of a fair trial right, or there was a risk of arbitrary detention under Article 5. All of those things being thought about in the Al Sadoun litigation. Why would the logic of this argument not apply there? Well, I suppose it's possible to say they're not as serious as the death penalty, but that would be jolly difficult because the common law has just as much set its face against other forms of CIDT as it has against the death penalty if implemented domestically. So if someone is confronting appalling prison conditions, for the sake of argument, does the principle apply there? And if not, why not? And that takes one straight back into the question, is it really appropriate for the courts to be doing this? Or if this step, both because of its size and its nature, as I described it earlier on, is to be taken, is that not a step that should only be taken by Parliament? The seventh submission is that the provision of material or information does raise, we submit, different issues in principle to those that arise when you are within the Suring principle and you are dealing with a person being sent back. That's a critical distinction when we come to international law, as I will shortly. I wanted you to take you to one decision domestically on this issue, and that's the Rangzib case. If you still have bundle 3 to hand, I think that was the last one we were in, and you go to tab 36, starting at electronic 2654, you will see the context in the judgment of Lord Hughes, sitting with Mr. Justice Owen and Mrs. Justice Thirlwell in the Court of Appeal Criminal Division, and you see the basic context from paragraphs 1 and 4 on page 2655 in the electronic. And the key paragraphs that I wanted to take you to are paragraphs 31 to 37. And again, they're some of them you can flick because I've taken the principles already, 31, for example, but start there if you would. See the reliance on the distinction that was positively drawn in the torture case, A number 1, and the distinction is set out at the latter part of paragraph 33. So the executive can rely even on torture-obtained evidence to protect the public and in making decisions, including those affecting individual liberties here. And they can share intelligence and information, even with states with practices that come close to the use of torture. And if you look, if you would, particularly at paragraphs 36 and 37, of course, we are nothing like that situation. Here we're dealing with the provision of MLA with a friendly and important foreign state, with a properly functioning court system and a proper rule of law. There are different rules and different constitutional positions in relation to the death penalty. But the points are that information provision cannot be and has not been dealt with by doing that which the claimant appears to suggest and seeking simply to apply some species of Suring type real risk or causation test. Such an approach simply wouldn't be squared with the statements of principle by Lord Justice Hughes and House of Lords in A. When the material is provided under informal or formal MLA, it's not necessarily to be used directly in court. It may be provided as here for intelligence or operational purposes, to allow further investigations, to provide the names of witnesses. That would cut across the basic reasoning that we see there. And we respectfully do not accept the inexorable logic argument that seemed to be the centrepiece of my learned friend Mr. Fitzgerald's submissions. We do not accept the first stage of that inexorable logic argument. The domestic position, of course, is that people in the United Kingdom are not subject to the death penalty. That was the position created by legislation as the proper arbiter of these things, we would add, when it abolished the death penalty and when it signed up to the protocol in the ECHR and that became part of the HRA. That wasn't a position created by common law. Our opposition to the death penalty does not lead to any lack of respect by the common law or the executive for the different constitutional arrangements in other states, including those that might respect the common law. The common law might well be opposed here now, although of course we've now got statute, but it would still respect those constitutional judgments in rule of law states abroad. And it would do so for the reason, we're going to go to this case later, so I don't invite you to go there now, I just invite you to note it. It would do so precisely for the reason given by Chief Justice Roberts in the Supreme Court of America in the Bayes case, Bundle 2, tab 23, starting at page 2241, but with this passage, which we'll pick up when we go there at page 2267. And in that case, Chief Justice Roberts said this: reasonable people, he said, of good faith disagree on the morality and efficacy of capital punishment, and for many who oppose it, no method of execution would ever be acceptable. We do not accept the second stage of the inexorable logic argument either. In other words, that opposition to the death penalty, as indicated in our domestic legal provisions and our constitutional setup, leads inexorably or logically to no provision of evidence, information, or intelligence, if only a causation can be satisfied. International law, which I'm going to come to as the next topic, international law recognizes precisely the distinction between the person being removed on the one hand and information being provided on the other. And my submission when we get to it is going to be that there is no CIL or anything approaching it to support a preclusion in international law, still less customary international law, of information provision to death penalty states. And the ECHR position is exactly in parallel with the international legal position. The Ismail case to which you were referred was a case involving the removal of a person. The starting point is thus that despite years of opportunity, there is no international law support for treating this as a matter of inexorable logic, flowing from domestic opposition to and the removal domestically of the death penalty. And the common law will respect and take into account and be infused, if you will, by that international and ECHR legal position. And I do not accept that the deeply entrenched domestic opposition to the death penalty equates to anything like that deeply entrenched domestic opposition when the question is properly formulated. And the question is, what should the attitude of the common law be when you are dealing with the cooperation as part of international criminal cooperation with a vital international partner by the provision of information that may assist a criminal investigation in their territory? There simply isn't any logical or inevitable progression from one to the other. And that is because, or not least because, an array of different questions are likely to arise in the context of, say, the provision of MLA. Difficult questions and different questions of a policy, of a legal, of a moral, of an ethical kind in relation to that simply don't arise in relation to the clear and narrow rule that governs the passing or deportation or provision of the person. And we see it in all of the submissions I made earlier on about the breadth of the common law principle. How would it work? Would it apply to all Article 3 cases? Would it apply, say, to an Article 6 flagrant breach case? And what happens if you have unpalatable choices pulling in different directions? Gitmo, or a rule of law trial in the federal system, but with the death penalty at the back of it? What happens when you put into the equation, as you have to, all the other complex of factors that applies in this sort of context and that creates the international diplomatic and international judgments that had to be made in a case such as this? And that is why my submission is that this area, this MLA area, raising those sorts of issues as it does, that is why it is peculiarly appropriate to be governed by the more flexible principles of public law, still controlled, but subject to those more flexible, more constitutionally appropriate controls, and why we say that if you're going to take a step with this uncertainty, with this consequence or set of consequences, that step should be taken by Parliament and not by the common law. And of course, you'll bear in mind that MLA provision covers a very broad area. It isn't merely vital, it covers a very broad area. It may have to be provided at great speed to be effective. It may have to be provided, and will often need to be provided, on a confidential basis at the earliest stages of investigation. And it's one thing, we submit, to have a clear, narrow jurisdiction-based principle around the person being within the jurisdiction and then being removed. It's quite another to have a hard-edged principle against which the provision of any evidence or assistance by information would be precluded. Can I turn to international law more generally? I said I'd deal with that topic. So this is going to be a new topic. The seven points have been laid out, and I'm turning to international law more generally. And I do so, as Lord Kerr will be delighted to hear, influencing or supporting. Or
Well, I might be delighted. It depends what you say, Sir James.
Or possibly,
To say.
influencing or
Don't
supporting,
count your
or
chickens.
possibly not, the existence of a hard-edged common law principle of the kind for which my learned friend contends. The Divisional Court dealt with this at paragraph 78 and following. My learned friend, Mr. Fitzgerald, referred to it only very briefly indeed, and only very briefly indeed for a reason, if I'm allowed to say so, and that is because on no view does international law impose the obligation or recognise the obligation that they seek to invite the common law to reach. I say international law, in essence it must come to customary international law, because mere international law plainly wouldn't do because of all the constitutional constraints, trend texts and all of that on their reception. It's only a source of law if it's customary international law, Queen and Jones and all those cases we submit. And of course, customary international law, let's be very clear about this, I'm sure it'll be well known to you, it requires a general practice of states and opinio juris recognised and accepted by states as having the force of law. I'm sure it was explained in that way in my Lord Lloyd Jones's judgment, but my note for some reason only has Mr. Justice Leggett explaining it in that way. So if you'll forgive the lèse majesté, in Mr. Justice Leggett's judgment, it's 271 on electronic 2817 behind tab 39 of bundle 3. So bundle 3, tab 39, 2817, Mr. Justice Leggett, para 271, for an explanation of what customary international law requires for a rule to acquire that status. And so the customary international law, those tests would have to be satisfied in relation to the specific obligation asserted. And again, I think that was a point made in the Al Sadoun litigation. It's no good just saying, for example, in relation to UNCAT, which was being considered in Al Sadoun, torture is a jolly bad thing and widely recognised as such, because the Convention Against Torture contained a whole series of specific obligations, some only of which had been incorporated into domestic law, and some only of which had been acknowledged or could be acknowledged as principles of customary international law in their own right. So we do respectfully submit that you need to have those rules satisfied, and they have to be satisfied in relation to the very obligation that you're considering for even the source to be flowing. So it isn't enough to show that there are lots of states and some international conventions now obliging contracting states not to subject people to the death penalty in their own jurisdictions, for example. So with that note of caution, we address what the international legal position is. And the true position we submit is as follows. Firstly, the imposition of the death penalty, even domestically, is not contrary to customary international law. The ECHR obligations are limited to the territories of those states that are signatories to it, plus the Suring principle, and Protocol 13 binds only those contracting states. The ICCPR positively permits it, positively permits the imposition of the death penalty even domestically, subject, of course, to the restraints that it imposes on states doing that. But the basic position is that it permits it, subject to those constraints. That is Article 6, Sub 2, Sub 4 and Sub 5 of the ICCPR, which you find in Bundle 13, I invite you to turn it up now, tab 137, electronic page 6683. It doesn't prohibit it, therefore, through Article 6, indeed it permits it, and it doesn't prohibit it through the back door, if I can put it that way, via Article 7 of the ICCPR. They cannot be read together as implying any understanding that the death penalty is universally to be considered as torture or CIDT, because otherwise you create an internal inconsistency and incoherence, given that Article 6 permits it. UNCAT is silent as to the death penalty. It does not contain any specific provision on the death penalty. In fact, it excludes the death penalty from the definition of torture in Article 1. It does not include, says that definition of torture, pain or suffering arising only from, inherent in, or incidental to lawful sanctions. The EU guidelines on the death penalty, which are in Bundle 2, tab 18, behind page 1939, reiterate that the EU has a strong and unequivocal opposition to the death penalty at all times and in all circumstances. But it recognises, if you take that up, if you would, I'll just show you this passage, if I may briefly. So Bundle 2, tab 18, electronic 1939. It recognises, if you go to 1940 and you look at Roman 2 in the introduction, you see the first sentence, correctly recording that that series of international instruments certainly establish strict conditions, but effectively permit the death penalty. So to show that a rule has the status of customary international law requires, as I've said, evidence that it represents the general practice of states and is recognised as having the force of law, but international law on no view provides that the imposition of the death penalty is unlawful. And the fact that abolitionist states regard it as morally wrong is not the same, of course, as saying that it's unlawful under CIL. And it follows that if the imposition of the death penalty is not contrary to CIL but is permitted in the manner we've just seen, it isn't an internationally wrongful act. It isn't an internationally wrongful act, for example, that would attract the provisions of the controversial Article 16 of the International Law Commission's articles. Again, I'm not going to go to those, so I'm probably not going to have time, but you'll remember what those do. Setting out rules of customary international law, and they govern the provision of assistance, the aiding and assistance of internationally wrongful acts by other states. It's Article 16. You need, if you're going to look at that article, you need the commentary as well, and the commentary we've included in our green file of further authorities if you need it. But the reason you need that commentary is because it indicates just how strict the conditions are in the International Law Commission's view, just how strict those conditions are before you start falling foul of that provision, Article 16. It requires an intention to assist and all of that. And it requires it based on international wrong by the state that you're helping. And if the state that you're helping has the death penalty, that isn't an international wrong, so you're not even past first base. But that's the position. The manner of the death penalty was the second of the topics, and it's right to address that because emphasis has been placed upon that. So we're not now on the international legal view of the death penalty per se. We're on the manner of the implementation of the death penalty. And the the real points to be made in relation to that, the first 2 points before coming to lethal injection and delay, which are the two basic concerns that are raised entirely properly by the claimant in this case about the American system. The two initial points are firstly that the case law in question is always considering very specific instances. None of that case law seeks to establish any sort of general proposition that would need to be mounted and established to base a customary international law rule. And for obvious reasons, you can't base or build any sort of general proposition on instances where there are, appalling as they may be, local mistakes. You have examples in the bundle of a domestic case which considered a challenge, I think, to removal in circumstances where there was evidence about the possibility that the US system would be open to mistakes in the administration of the death penalty. Can I just give you the paragraphs and leave it for that purpose? This also is called Al Sadoun, but it's a different one. Again, it's the third Al Sadoun I've referred to, I'm afraid. And this time it's Law Justice Laws. Bundle 3, tab 38, page 2734, and the relevant paragraph numbers are the three relevant paragraphs, 68 to 70. And he basically concluded, well, the English court isn't in any position to make judgments of a systemic kind based on evidence that had been placed before the court as to the possibility of error. And of course that applies
Well, about the possibility of error, certainly. But in this court, we have been invited to consider the average waiting times as testified to by, I can't quite remember the name of the individual concerned.
Mr. Fagan was it, or
Yeah.
Professor Fagan?
Professor Fagan, yes, you're quite right. Well, are we entitled to look at those?
My lord, you are. You are, and of course, the evidence is before the court. But the question is whether you're entitled to proceed to conclude that the American system, for that reason, is as a system contrary to international law or contrary to some principle of customary international law. And my submission is not, for reasons that I will come to. I'm going to take lethal injection first and then come to delay. So I start with two basic propositions. They're linked. The second of them is that much of the case law is positively against any general propositions of that kind. So if one goes first to lethal injection, and the use of lethal injection, can I invite you to take up the Bayes and Rees decision, bundle 2, tab 23, put bundle 3 away. Key judgment for present purposes, it's the judgment of the plurality, was that given by Chief Justice Roberts, which starts on electronic 2246. Just to describe describe what the case was about, it was held in this case that lethal injection or the proper administration of the particular protocol which had been adopted by the state of Kentucky did not violate the Eighth Amendment. It did not do so because it did not create a substantial risk of unnecessary infliction of pain, torture, or lingering death. It was accepted by the Supreme Court that if properly carried out, it would be humane and constitutional. And you see that the position really in this case taken was to argue for one test rather than another. So that was the real issue that divided the parties before the court in this case. Kentucky, the state of Kentucky, was urging the court, as you see at the top of page 2254, second full, or the sentence just above the letter A at the top of page 2254, and said Kentucky urges the court to approve the substantial risk test used by the courts below. You see that the petitioners conceded that if performed properly, an execution would be humane, carried out under Kentucky's procedures would be humane and constitutional, 2255, 3 lines below the letter B. And then you see the true nature of the debate at 2257, under the letter C. Dispose of the issue of principle as to what the test should be. Should it be a risk of significant harm, or should it be the mere raising of a possibility, or slightly or marginally safer alternative? And a test of unnecessary risk, which they reject in the final 2 or 3 lines on page 2257. Instead, over the page 2258, the substantial risk of harm test. But they then subject the considerable evidential analysis of the courts below to their own probing analysis in the paragraphs and pages that follow, and that is a factor of at least some interest and importance. All of the US courts are examining these sorts of issues, and they're receiving evidence as to the appropriateness or otherwise of the particular protocol and the particular method of carrying out the death penalty. The passage that I said I was going to alert you to, because I referred to it earlier about reasonable people of good faith disagreeing on the morality and efficacy of capital punishment, is at page 2267. Just below the 3 stars in the middle of the page. Reasonable people of good faith, do you see that passage there? And you see a similar approach to the approach in Bayes and Rees in another case, which I don't invite you to turn up, but it's another US Supreme Court case. It's again about the humanity and so on of this method of administration of the death penalty. It's a case called Glossop and Gross, and it's in bundle 2, tab 25, if you want it, 2342. It's important that at least you have the location of these 2 cases, because I think my learned friend Mr. Fitzgerald placed quite considerable reliance on judgments in either one or both of these cases, Justice Sotomayor and so on, but they were dissenting judgments, it's to be borne in mind.
I think it was Justice Breyer principally, but...
Justice Breyer, and then I think Justice Sotomayor as well.
Justice Sotomayor.
Yeah, but they were both, as he fairly acknowledged, they were both dissenting judgments. But that's where you find the US thinking on this. And the basic approach, therefore, is the death penalty is constitutional as a sentence, as it were. Lethal injection is not cruel and unusual, contrary to Article 8. Test they apply is one of substantial risk of serious harm. any profit alternative has got to be feasible, readily implementable, and a significant reduction of that risk of severe pain, as they put it. But the key position for present purposes is that the courts in that country, unsurprisingly, given that the US system is one governed by the rule of law, the courts are directly and actively engaged in considering with great seriousness, right up to the level of repeated Supreme Court decision-making, those constitutional issues of real moment. There are challenges to the method. They don't just go by the board. They're carefully examined. They're the subject of evidence in the state courts. They're ruled on by the courts. They reconsider the position if there are certain to be changed circumstances or new drugs have become available which carry a lesser risk. They reconsider the issue. So that, we respectfully submit, entirely unsurprising position in the US court system suggests very strongly that it's unlikely that you're going to find a rule of international law, a fortiori customary international law, against that method of administering the death penalty. And again, equally unsurprisingly, there's nothing whatever in the international law materials that you have to suggest that it regards the lethal injection administration as being internationally unlawful. So, for example, and for that purpose, see Cox and Canada, Bundle 10, tab 114, electronic page 5748. It's worth turning that up very briefly. So 5748 is the first of the paragraphs that I want. This is the Human Rights Committee, so the ICCPR body, and the first paragraph is 13.5. Volume 10, 114, page 5745, para 13.5 first of all, then 14.3, and then in particular in the reasoning, 17.1 and following to the end of para 17, including in particular 17.3.
It's 1 o'clock, Sir James.
Oh, I shall stop then.
Well, you seem to have reached a
I
point
ground
at
to
which you
a
were
halt.
drawing breath, so I thought I might just...
I'm sorry. So I shall ground to a halt inadvertently.
Well, we'll adjourn now and look forward to hearing from you further at 2 o'clock.